my lord, board's appeal, that is, my lord, MAT 873. My lord, you will kindly take the volume 1.
You said you all are untrained. Everybody is untrained. Do I
Yes,
got?
my lord, I am just untrained general, right? আমাদের কোনো reserve feather নেই.
Yes.
They all are untrained. My lord, you will also kindly keep it in mind, my lord, these entire, my lord, cancellations of, my lord, selection process relates to untrained candidates.
Yes, yes.
Now,
So you mentioned untrained, no? So I was in doubt.
that's
Anything. Anyway, yes. What do you want to show?
yes. Now, you will kindly take there was no amendment to the writ petitions, which was originally filed, that remains.
Yes.
No amendment application filed. The what has been, my lord, stated in the writ petitions, that was only affirmed by the petitioners and took responsibility thereof. Now, kindly take the writ petition once, my lord. It's in page. Let's say start from page 1. Kindly take page 36. The paragraph starts.
Yeah.
All right, paragraph 2, I'll be first showing that your petitioners are unemployed, educated youths of West Bengal. They do not have any regular permanent employment in spite of having qualification.
Paragraph 6.
Paragraph 2, page 36 of the paper book.
Yes. Yes, Mr.
Yes. They do not have, your petitioners have common cause of actions and they have decided to file this case jointly. The petitioners are praying before this court for exemption of the court fees. Then, my lord, documents of the petitions number 1 to 10 and documents of the petitioner number 130 to 140 showing they are TET qualified are being annexed here too and marked with letter P1.
Yes.
Then, my lord, paragraph. So, some of the petitioners, as they have pleaded, were TET qualified as per their own pleadings. Pleading. As per pleadings, they didn't say that they are all qualified, but in fact, as my junior said, they are all qualified, but they said only 10, 20 of those petitioners were TET qualified. Your petitioners, next paragraph 3. Your petitioner state that on 19th October 2002, the West Bengal Board of Primary Education published notification for recruitment of assistant teacher in primary school. It is needless to state that there were huge irregularity in TET 2012 and several cases were filed.
Yes.
We are not concerned with TET, but they, my lord, cited it. In spite of irregularity and illegality, 18,000 teachers were recruited and the government of West Bengal gave one exemption to the aspirants of TET 2012, that the aspirants of TET 2012 can sit for the next examinations, and in that case, they shall be exempted from paying any fees for the examinations. Now, just pausing for a moment. These, most of the petitioners, they appeared in 2012 recruitment process, were unsuccessful. Then they participated in 2014 TET and 2016 in recruitment process. All they became also unsuccessful. It was not stated. Now kindly take, my lord.
Yes.
Paragraph 4. Your petitioner states that on 12 November 2014, National Council for Teachers Education has published a notification such and such, and in that notification, qualification and other procedures for recruitment are prescribed. Now, your petition states that on 9th April 2015, Ministry of Human Resource Development, Department of School Education and Literacy Government, extending some relaxations to the state of West Bengal till 31st March 2016 with certain conditions. Now, if you lordship sees annexure P4, it says that this extension was given because the minimum qualifications is TET qualifications and the DLE, the training qualifications. Now, so far as this extension was allowed with respect of that the untrained candidates can be recruited up to 31st March 2016, and they proceeds on the basis. What happened thereafter, I'll show. What the writ petitioner proceeds on the basis that the last date for appointment of untrained candidate was 31st March 2016.
No, that they have not said. They have said.
Yes, that is the specific case. Your relaxation,
relaxation was up to March 2016.
That case was also that up to, I'll show, next. Then, paragraph 7. I'll show certain paragraphs.
Is it their case that you having been appointed in March 2017?
2017, so we are entitled.
Stand, huh?
So we have been given special privileges, so they stand on the same footing, they should be given the recruitment.
Right. They are not saying that appointment is bad because within that period they have not.
That twofold. One is last cut-off date was 31st March 2016. It could not be extended. Then is since the state government,
But
board
prior
has
to that, the selection process started.
selection process.
31st March.
No, there are two processes. One is state process for
Date
state.
is of
2014. Selection process started in the present case September 2016. The notification came in September 2016.
Advertisement came.
Advertisement.
Recruitment rule was of 2nd of March 2016. That is prior to 31st March.
Prior to 31st, but the process was started on September 2016. What happened, Malad? This date was subsequently extended till October 2017.
This 31st March?
Yes.
Where do we find that?
Malad, that. Auto volume kano? Duto.
Achha, you tell us up to when it was extended.
Malad, 10th October 2017. That was the last date, Malad.
Prior to that advertisement published.
Even prior to the appointments, after the appointments given, prior to that date, all appointments given.
Prior to October 2016.
2017.
Extended till October 2017.
17. I'll show that. Take it from me, Malad. Show. Malad, there was a judgment of the landed single judge permitting, Malad, even after the lapse of this period, permitting the state government to carry out the selection process. No appeal. Malad, ultimately, the Ministry of HR, Human Research, and they.
No, Mr. Bondo, is it their argument that since the date expired on 31st March?
I'll show from the pleadings itself.
Sure.
I'll just going on.
Yes, we are in paragraph 5.
Paragraph 5.
Yes, then which paragraph?
Then paragraph 6, they said this 14th July 2015, Government of West Bengal has published notification. Then 7th TET examination held. Paragraph 9.
Yes.
Your petitioner states that on 14th of September 2016, the result of TET 2014 was published, but no merit list and scorecard was given to anyone. On 26th of September 2016, notification was published for appointment of primary teachers for TET 2014 to fill up 42,949 vacancies. Everyone said that out of this, 32,000 and something is for untrained and the rest are for trained. Now, these are the total vacancies. In that notification, it was clearly stated that the candidates with minimum qualification as specified in MHRD will get preference, and after the eligibility candidates with relaxed qualification may be good. It is needless to mention that MHRD gave relaxation only till March 2016. And in spite of that, the board notified that the candidates who do not have training will be considered too.
This is the only line they have used in the entire petition.
Now, what they have used, I'll show, Malad. I'll just read, I'll not touch anything. I'll just go on the writ petitions. But what is my first point? First point is, Malad, under any circumstances,
Yes.
under any circumstances, an untrained candidate could be appointed up to 10th of October 2017. Let's keep it in mind. And according to them, it was up to March 2016. 10th August, well, I'm sorry, 10th August 2017. Up to.
Yes.
In the present case, my lord, all appointments of untrained teachers were made in between February to April 2017. There was no other appointment for any untrained teachers, my lord, after April. These dates are vital, my lord, because to show that the writ was not maintainable in 2023 or 22. Also. My lord, up to 10th August 2017, an untrained candidate could be given appointment in the state of West Bengal. All appointments which have been given in the present case was in between February 2017 to April 2017.
Yes.
My lord, according to their statement, they participated in the interview process. My lord, there was no contemporaneous documents, my lord, not even a letter written by any of these petitioners, or either to the board or to the district primary school council, saying that you see this interview was contrary to the rules. My lord, no aptitude test was taken.
Yeah, that has been argued. That this
No,
is
not a single document. Now this was not there. Now, for the first time, they came and in the writ petition,
in 2022.
2022. Now, their prayer in the writ petitions, I will be coming back to their smaller paragraphs. Kindly take their prayers.
Yes.
47.
Yes. Yes.
First prayer, my lord, to act then. To direct the authorities to file report disclosing the names and numbers, rank categories of all non-trained candidates who have been recruited till date in primary school from TET 2014. Then to direct the authorities to treat the petitioners equally with the non-trained candidates who have been recruited by the board after expiry of the relaxation given by the MHRD on 9th April 2015. That was their case. I had shown MHRD gave relaxation as per them is 31st March 2016. Now, my lord, it cannot be, because the state government or the board has no independent authority under any circumstances. Even if any appointment given, they do not get any benefit from that appointment. If any untrained teacher was appointed after the cutoff date, they could not have acquired the training, because the training was for them up to 18 months. That completed in 2019. The last date of obtaining training, that also stood expired. So their case in 2022, it is not maintainable at that time. May I clear to your lordships?
Yes.
In 2022, none
have
of the prayers could be
You
granted.
have already become trained.
Yes.
That is what Mr. Pratik Dhar argued.
No. Question of training, whether
Under Rule 3 provides.
under the MHRD guidelines and the rules, my lord, only those persons who were appointed prior to 10th August 2017,
Right.
they could have obtained this training.
Yes, yes.
And for training, it was 2 hours, instead of 2 years training, they were given 18 months period. That was the relaxation given by the ministry. Now, nobody can claim appointment after 10th of August 2017 pursuant to 2016 recruitment process. Even the state has no power, even the board has no power, even the court has no power. Forget about the learned single judge, even the division bench has no power to give appointment after 10th of August 2017.
Yes.
So delay is another thing altogether. I say, my lord, in 2022, these writ petitions in the present form was not maintainable because this was an individual. This is a writ petition filed before the learned single judge, not a public interest litigation, my lord, for scrutinizing the entire selection process. But when these writ petitions became futile or infractious as of the date of the filing of the writ petition itself.
Because by that time the time had expired.
By that time, everything has gone.
Yes.
And this issue was not considered by the learned single judge. But today, unfortunately, we didn't get any opportunity to file affidavit before the learned single judge. We approached the Honorable Supreme Court. We had to approach the Honorable Supreme Court. We are not added parties. Now, these 139, most probably petitioner, these 139 persons had no locus in 2022. This was filed most probably in September. The learned single judge was also aware. In another similar writ petitions, what the learned single judge said that you came now after 7 years. So this writ petition is not maintainable. Same learned single judge, but I have given the copy. I'm just reading. I'm giving the this is order dated 3rd of April 2023. The petitioner is Sharadindu Panda. I have got this writ petition. The judge was learned Gangopadhyay.
3rd of April.
3rd of April 2023. When this
Where do we find that?
My lord, may I just hand over a compilation? I'll not travel with any. Only one judgment I'll be show. Only two, three orders. The first page itself, my lord. I'll be very precise. I'll try to complete it by. I'll show that there are paragraphs also. First page. This writ petitioner was untrained.
Yes.
Same learned single judge, he was hearing, probably some special interest was showed, my lord, don't take me amiss, my lord, I am bound. Because the learned single judge, my lord, sometimes, my lord, when one is.
Let us not talk.
I'm not. Don't, my lord, with utmost respect, but I think, my lord, there was something. Second paragraph, your lordship has seen, as the application has been filed after 7 years from the date of interview, I do not entertain the writ petition and same is dismissed. Now, again, your lordship kindly come back to the writ petition.
Here the judgment was on 24th of
April 2023. Impugned judgment. 3rd April 2023. Impugned. It is on 12th of May 2023. In this matter, the impugned judgment was delivered on 12th of May. At that time, this matter was hard. Your lordship had seen, my learned friend Abroto Sudhar has shown all the orders passed at different occasions.
Yes.
So when this matter, the learned judge was conscious that this writ petition could not be entertained, but for this special writ petition. And today, because of his endeavor, now we are fighting the case for these 32,000 jobless persons. And now because of the SSC, they are afraid.
Board also did not show these materials. Your argument could have been more substantial if you had shown that board placed this order before my lord. Board also did not.
They had the obligations to make us party. They did not make us party.
Board also didn't say this fact which you are arguing. So let us not go into those issues.
No question of board showing. Board failed. Board, he was represented by some advocate. He might have failed. But if any one of these selected appointees, if they were made parties,
so
they could have brought it to the notice of the court.
Who was appearing for the board.
He failed. But this was the same learned judge. Yes, I would have appreciated that it was passed by a different learned judge. It was by the same learned judge. Now kindly again come back to the writ petitions, my lord. Paragraph 10.
Yes, para 10.
Your petition states that after notification, the procedure was started for appointment from October to December 2016.
Yes.
The interview and verification process started on 31st of January 2017. Even at that time also, they did not raise objection. We could not have started this process. 31st March 2016 was the last date. Now they participated. Allegedly, the result was declared, but there was no panel, there was no merit list, there was no category-wise merit list, no division of numbers, rank was given to anyone. In website of the board, there was dedicated space where a person could see whether he or she was impaneled or not. Mark it, my lord, because everyone can see. I have got the screenshot of the website. Then the full merit. I don't mind, my lord, what is merit list and panel, what they meant to say, my lord. No merit list was ever published in spite of repeated requests. The full merit list was not made to public. Allegedly, it was stated on 31st January, stated on 30th January 2017. List of trained candidates were published. My lord, full stop. My lord, there was a full stop. Kindly take it, my lord. This allegedly it was stated on 30th January 2017, list of trained candidates were published. Paragraph 10, page 39. This is for trained candidates. Kindly mark this, my lord. This allegedly word was issued. It was stated on the list of trained candidates were published. This is meant for trained candidates. This allegedly. They may say that we have stated allegedly, but they have used this word allegedly for trained candidates.
So list of trained and untrained were separate?
Separate. That is
in
the
all
next,
the districts. In all the districts.
On district, they did themselves have stated on the same line on 4th.
So how this list of trained was published by people?
They themselves have said on the DPSC board. And a published dictionary meaning also is not make known to third party.
Yes.
Now that was as per rule. Now then on the same line, my lord, page 39, kindly take, my lord, how they have stated and how the learned judge proceeds. My lord, on 4th February 2017, that is after the stop, on 4th February 2017, list of non-trained candidates other than Bengali medium was published. This is their case, it is not my case. I did not, my lord, elaborate anything because that was the case made out before the learned single judge. And the panel was published.
8th February?
On 8th February, list of non-trained candidates and candidates from Bengali. Now, other than Bengali medium on 4th and 8th of February for Bengali medium were published. That is their own statement. on oath. And it has been affirmed as true to their knowledge. Page 45 is there.
Yes.
Page 50, kindly take this, their affirmations. It was affirmed as true to their knowledge.
Yes. Which paragraph you want to show next?
My lord, next is 11.
Yes.
Now, may I just my lord, continue these paragraphs? It was
Yes.
published on 4th of list of 8th. From the dates and the list, it is clear that all trained candidates of TET 2014 were appointed through the first list, and after completion of the same, as per notification dated 2nd March, to the board appointed non-trained candidates. So they were also aware of the appointment of non-trained candidates. That is more evident from the 11. Your petitioner states that on 23rd, now they are trying to explain the delay or something like. Your petitioner states that on 23rd December 2020, 15 February 2021, 17 February 2000, notices were published for recruitment as assistant teacher in private skill from TET 2014. The board has appointed non-trained teachers after 2016, even and intentionally ignored the petitioner by giving excuses of notification issued by MHRD by such and such. Again, I am saying that was the case made out that after 31st March 2016, no appointment. Thousands of non-trained students were appointed and petitioners, though similarly placed, were ignored. If it is stated, if it is a stand of the board that no non-trained candidates can be appointed, then all appointments of non-trained candidates made after March 2016 are bad in law.
What did they mean by that? If it is the
They
standard,
said that after March 2016, no non-trained candidate could have been appointed because the MHID notification, that is the cutoff date. But the board had given appointment to the non-trained candidates beyond 31st March, so they should be given appointment.
where is that notification
Yes,
of
Malad.
August 2017?
Compilation.
Page?
My lord, I have given another compilation, that is list of events. Kindly take. I'll not show any. All documents have been given, including the learned the order of the Honorable Justice Kandan extending that, my lord, selection. Straight away come to, my lord.
Kandan's order is page 63.
Debo, Baba, stop Debo. Has you got it?
Page?
Page is, my lord, the page, kindly take 103.
No, Mr. Bandyopadhyay, even if this point is not taken, suppose extension, assumingly it was till 31st of March 2016.
Even then the writ was not maintainable. That is why I am saying.
Let us 31st March 2016 was the date for completion of that qualification. Relaxation given up to 30. Now the employment recruitment rule was of 2nd March 2016. So this point, I don't know what they will be arguing. Is it their case that since the relaxation period has expired, no appointment could have been made of untrained candidates?
Again, come back to page paragraph 11.
No, this is one aspect of the matter. And the other is, suppose you do not consider August 2016. If we take extension was up to 31st. Since the selection process commenced prior, recruitment rules were framed prior to that. Then whether this relaxation will still apply after the board has published commenced the selection process?
Yes, because this is the mandatory qualifications, my lord, as per under the Right to Education Act.
That is why 3-2 proviso was given, that once you are appointed, you can complete this.
See, my lord,
I think I'm not clear to you.
So far as the untrained candidates is concerned, There was a time period given under that particular notification.
আচ্ছা দেখি আমি
Your
Which
lordship
page?
kindly first take that first notification,
page that is page 95
MHID.
MHL.
Yes, that your lordship has got it. Now
not-
kindly take one judgment,
আবার যা যা আগে মেমোটা দেখি
not judgment. This is sequence. This was sequence of event. Karnaneta কোথায়?
Page 63.
Page 63. Kindly take page 63. By that time, no extension came. 14th of September 2016. Page 63.
yes what is this
Kindly state the operating portions. I am not. But Mr. Shubhi Sharnal was appearing at that time.
no this by this extension was given by the
Yes,
court.
by the court till the extension is obtained from the central government, from the ministry. Kindly take page. Page 73. Kindly come to page 73.
yes
Bottom. It will make the position clear. From the above deliberations, the views of the court are as follows. May I?
yes
The state government sought relaxations from the second respondent herein, namely the Ministry of Human Resource Development and the School Education Literacy Department under the provisions of Section 23(2) of the Right of Children to Free and Compulsory Education Act 2009. The rules framed thereunder in order to fill up the entire vacancies with the untrained candidates, since there are no adequately trained candidates who are presently available. The sixth respondent had granted relaxations after certain conditions. Similarly, the trained and untrained candidates shall be appointed to the available vacancy, as the trained candidates will not be prejudiced in any manner. The state government took the stand in order to provide proper educations to the students who are in poor need of the same in the entire state. Education is a fundamental right to the state. The learned additional advocate general rightly pointed out that approximately 40,000 vacancies are available as of now. The sixth respondent's condition that the state government is to first absorb and appoint the trained candidates and thereafter appoint the untrained candidates. The trained candidates, as per the statistics by the learned additional advocate general, are about 19,495. Therefore, the untrained candidates' appointments will not be disturbed with the trained candidates. All the respondents are strictly to follow the logical use as per provisions of Section 23(2) of the Right to Chair. The notification dated 1st of April 2015 granted an extension of the relaxation up to 31st of March 2016. But due to the General State Assembly elections, the appointment process has been kept in abeyance.
Hmm.
As such, there is no lack of service on the side of the state government of West Bengal. Therefore, this court permits the respondent number 1, 2, 3 to proceed in the mode of selection for appointment of teachers. Further, respondents are liberty to approach the respondent number 4, 5, and 6 in order to extend the relaxation.
where is that 4th August up to
Yes,
August?
now that August you will file 103, page 103.
page 103
Is it legible, Malad?
even then we have to read yes page 103
Yes, it is of National Council of Teacher Education, Malad, notification dated 22nd September 2017. This notification was not there, Malad, in the first compilation placed by our senior friend Mr. Kullan Bandobadhyay.
no this is of NCT
NCT, Malad, I am coming, Malad. This is
page 95 is of Ministry of Human Resource Development
yes,
extension
no, Malad, both, Malad.
MHRD
Yes, MHID and Malad. Under the same, I will show the relevant portion.
central government has to relax not NCT
Under the
That's-
specific Malad, provisions of the Right to Children and Free Education Act, this
23.
notification was also issued.
kindly come to page 95 this is of central government did have the authority in consultation with the council maybe page 95 of Priyanka
The MHID notification. Yes, I mean, kindly
Has
take.
there been any MHRD notification?
Yes, Malad, that has been referred to in this. Malad, that is why.
Sure.
And whereas, Malad, last and whereas,
Huh?
in view of the above mentioned directions of the Ministry of Human Resource Development under Section 29 of the NCT Act, and after considering the recommendations of the expert committee chairperson in NCT in exercise of his power under clause 12 of the NCT recognition of norms and procedure regulation 2014, granted relaxation by the NCT headquarters such and such, and later to the following provisions in the NCT regulations 2014 for ensuring that the directives of the MHRD for implementing the amendment to RT Act 2009 are duly fulfilled. Then, Malad, kindly skip this 1 to 4.
Yes.
Then, Malad, next page 104. This 104. And whereas, Malad, I'm just skipping the first part. And whereas,
Yes.
after having considered all the above facts and figures, the NRC considered the case in its 275, decided that the recognitions be granted to the National Institute of Open Schooling for DLED against scheme, Malad,
Data boy.
that is for the DLED training. That is meant for training to the untrained candidate. Next page, 105, serial number, Malad, Roman 8.
18. Yes, read that this program shall.
This program shall only be for those in service, untrained teachers in the private unaided schools appointed on or before government aided and private unaided schools appointed on or before 10th of August 2017.
This program, that is program is pertaining to
DLED, Malad,
DLED,
that is the training qualifications. That is to be obtained by the Malad all teachers. As per Malad, all untrained teachers. NCT regulations, the DLED to be obtained. And in fact, the 2024 judgments, Malad, cited most probably by Pratik Dhar, that refers to these. So, up to 10th of August, Malad, there was no other relaxation. But after 10th of August, Malad, there was no scope of appointing any untrained candidates. And no appointment in the present case has been made after 10th of August.
yes.
That is the cutoff date. So now they were aware. Malad, they didn't say it because they said that 31st March 2016 is the cutoff date. Even then, Malad, on their own pleading, the writ was not maintainable in 2022 because no appointment could be made. Because there is no Malad, negative equality, Malad, that one wrong has been committed, so they should be given the.
March 2019 that degree of DLA.
Just come back to page 104. But one explanation probably that may confuse your lordship subsequently. That is why. But page 104, serial number 4. After the whereas and whereas, serial number 4. Just mark it, Malad. NIOS shall operate study centers manned by staff by academy as per instructions of NHRD to enable NIOS to complete the training of in-service untrained teachers numbering around 11 lakhs by 31st of March 2019 all over India. And that is why this 18 months, instead of 2 years, that was relaxed, reduced to 18 months, which have been subsequently approved by the Honorable Supreme Court in 2024 judgment. May I clear? Because requirement was 2 years. Because of this decision that one must have this training by 31st March of 2019. Now 10th August was the cutoff date, so they are not getting this 24 months. They were only getting 18 months of training. So for those teachers, it was relaxed. And ultimately, which has been approved by the Honorable Supreme Court, relied upon by Mr. Pratik Dhar repeatedly. Page 104.
Yes.
Now, kindly again come back to page 39 of the paper book, paragraph 11 I have made. That is their case. After March 2016, the appointments are bad in law. So how could you file this petition in September 2022? You are asking to be further wrong to be committed. It was your belief. Now what they are shifting. This was their individual case. They saying now what legal right they had on that date.
Yes.
This is a fundamental of mandamus that one has to have some either fundamental right or legal right breached. What legal right they had in September 2022? After 31st March 2016, when they are themselves, their cases after 31st March 2016, no appointment. Have you approached the court before 31st March 2016?
Yes. Anything else, Mr. Bandyopadhyay?
Yes, my lord, I'll be only limiting my argument on the writ petitions. I'll not travel beyond. I'll show another thing, my lord. My lord, why they have shifted now their case to make it as a public interest litigations, and landless single judge readily accepted this. My lord, page 40, paragraph 12. Now they are shifting to scam. Page 12, paragraph 40.
Yes.
Your petition states that recently the TET 2000 busted in West Bengal from several cases lodged by CBI and from several orders passed by the Honorable Court. The petitioners came to note that several illegal appointments have been given by depriving the petitioners. I don't know on what basis they are stating. Because TET was not challenged. TET is qualifying examination, just like JEE. TET 2014 was a qualifying examination. They did not challenge that qualification. On the other hand, their cases all are TET qualified. They are saying that they are TET qualified. But they were shifting because these allegations of scam related to TET 2014. TET 2014 has not been under challenge. Then they are shifting to the 2020 also recruitment process to make it
Yes.
Then page 40, now they are trying to shift it to 2020 selection process. Non-trained candidates are the worst sufferers of this scam. They are not challenging my appointment. They said non-trained candidates are the worst sufferer of this scam. Now on 23rd December 2020, the West Bengal Primary Education published one notification for recruitment of 16,500 primary teachers. And in that publication, they have stated candidates whose qualifications as per guidelines of NCT. Such notification is absolutely illegal, as qualification should be measured as on the date of qualifying TET. Every 3 lines has some different meanings. This is for 2020 selection process. In 2020 recruitment process, the state government or the primary the board had no authority to say any non-trained candidates has the opportunity to apply. because by that time, long back cutoff date has expired. Now only trained candidates could be appointed. Now what their case? Since I am qualified in 2014, so I should be given chance to participate in 2020 selection process.
Yes.
Then the next. Now, as per the action, after 4 lines, you'll see has got it the same paragraph. As per the action, now the scam. As per the action of the board and as per different statements given by the then president of the board, Mr. Manik Bhattacharya, all trained candidates were recruited as per notification of the board. The petitioner should get fair chance to the recruitment, but the board has done a complete injustice to them. If it is the stand of the board that non-trained candidates cannot be appointed, then all appointments post March 2016 are bad in law. You will say, put in the question, is it their case that after 2016 no appointment? That was their case. Board should apply some theory to everyone, and board cannot simply pick and choose between the candidates. The petitioners are TET 2014 candidates, and they deserve the same relaxations which was granted to the other non-TET candidates. But where is the case that no aptitude test was taken, the selection process was vitiated, the interview was vitiated, there was no guidelines framed? Where is this case in the writ petition? The learned single judge with utmost respect took the responsibility of making the writ petitions better for the benefit of the writ petitioners. Where is this case? Next paragraph, page 1.
You can skip that para. You can skip that para.
14. Yes, though, no, why?
Now they say they are
I'm not reading it. I'm saying these were all trained candidates which numbers were given, roll numbers.
Yes.
Then, my lord, এক সেকেন্ড দাদা আমার মতন পড়তে আমিও দাগ মেরেছি প্লিজ paragraph 14 please. I'll show that. Sorry.
No, you have reached up to page 41, paragraph
13. 13 I just, yes.
You one line you have missed, 4th line. It is there also there.
There was huge illegality in the whole selection procedure of TET 2014. This is TET 2014 was not selection procedure. This was qualifying examination.
2014 was an illegal TET which was they are saying, but they participated
On the basis of their TET qualification in the selection process.
Yes.
Yes. They are not challenging this TET. I'll be only.
So they on one hand say that we are TET qualified.
I said there was a scammy TET.
No, this TET is bad.
Bad. Now I'm further going, my lord. Paragraph 14.
We have been taken through this. We have gone through this.
No, my lord, I'll show, my lord. I'll not show entire paragraphs. I'll just show only 3 paragraphs, my lord. 14. Your petitioner state at present there is more than 1 lakh vacancy in the education department of West Bengal. Since 2011, several examinations conducted to fill up the vacancies, but a single recruitment procedure could not be completed without corruption and irregularity. That's fake. They did not contemporarily challenge anything. They said every selection procedure was marred by corruptions.
Yes. Yes.
Next, 15. Your petitioner further states that on 30th April 2022, that their cause of action starts from 30th April 2022.
Hmm.
My lord, they could have applied before the court only up to 10th August. 30th, Srimati Mahua Mitra, Honorable Member of Parliament, Krishnagar Lok Sabha, made a statement before the media pointing irregularities in TET panel. There was no TET panel. My lord, TET is qualified examination, whereas to secure minimum marks to qualify. The recently person lodged a complaint against one MLA of one political party. MLA took crores of money from George Banerjee with a promise to give them job in the schools. And in that case, personal assistant of Tapos Saha MLA, was arrested. The statement of Mahua Mitra described the situation prevailing in the state of West Bengal. No complaint was annexed. No statement was annexed.
Yes.
No
yes.
particulars have been given there. Then, my lord, just keeping, my lord, since you are now 18 is the most relevant paragraph. I'm skipping the other portion, how they have made out their cases. Then again, my lord, paragraph 17, one line.
Read the first line of para 70.
Yes, that is why I'm reading. Your petitioner states TET 2014 is the biggest scam of the education department.
But they had been successful.
They had been successful, but they are challenging the recruitment procedure initiated in September 2016 by which we got appointment.
Yes.
They did not challenge because TET 14 was not under the in the prayer. They didn't challenge it. They challenged nothing.
They challenged through their averments. Date is where.
Yes, that is permissible, most probably.
Yes.
Well, 18 is my last paragraph. I will be.
Yes.
Your petitioner states that the board has stated in different cases filed before this court. They are so vigilant. They did not approach, but they are vigilant. Your petitioner says the board has stated in different cases filed before this court that 42897 candidates were selected till date, but no merit list of such and such was ever published. As pausing my moment, but how they could know in different cases what board has pleaded? They could have approached earlier. This was candidates was ever published by the board should be directed to publish the merit list by disclosing the numbers obtained in written interview and reservation category wise list should be published. Candidates were informed through SMS and no merit list of candidates was published. It proves that the mischief in the recruitment process. If the process was free from all corruption, then they ought to have been transferred merit list of TET 2014 qualified candidates. What they are actually contending, panel in the recruitment process or TET qualification. Again, it is not clear. So these are all vague allegations.
Yes, yes.
Now, the process was not, now this is the last 5 lines. This process was not completed in February 2017. And the department is well aware of the same. And this honorable court should take notice of the same. Persons who did not qualify for TET 2014 were appointed as primary teachers by the board in spite of specific case steps were not taken, and shows there was corruption and illegal financial transactions while conducting the recruitment process. Not a single instance, not a single particulars, wild allegations. This writ petition should have been dismissed with exemplary cause.
Yes.
Then,
Yes.
my lord, one should, my lord, if your lordship don't take me amiss, this writ petition was used for, my lord, some political gains at the cost of livelihood of 32,000 teachers. Not only their livelihood, their family members' livelihood, only for the purpose of their, only for the purpose of satisfying some vested interest, which has nothing to do with this recruitment process.
All right. Yes.
Now, next. But while conducting the recruitment process, the department ought to have taken suo motu steps, but that was not done for reasons best known to them. Moreover, many candidates complained that TET 2014 qualified certificates were not issued to them. And even today, they are fighting for that. There is no delay in filing public interest litigation as the corruption is still continuing. Now, what is the cause of actions? Corruption or this recruitment process? I'm just putting a question to myself.
Yes. Yes.
Still continuing, an honorable single bench of this honorable court also passed several orders regarding TET 2014 even in September 2022. So that's why they come in September 2022 file, and they were probably, my lord, most, my lord, they believed in their heart that their petitions will not be thrown away.
Yes.
Now the grounds. Next page, page 45.
Yes.
Round 3. Page 45.
Hmm. Yes.
No, there's some limit in copy paste, I'll show. For that, the department has recruited non-trained candidates after expiry of the relaxation given by NCTA, but not recruiting the petitioners. Now, after relaxation given by the NCTE, the relaxation was given up to 10th of August 2017.
Hmm.
Because other relaxation was MHRD. So they were aware that relaxation was given up to 10th of August 2017. Otherwise, they could not have referred NCTE.
NCT was a party. NCT was a party.
Yes.
Next. 5. Kindly mark these grounds are interesting. For that, board has committed fraud upon non-trained candidates and did not follow their own notifications.
Hmm.
Equal rights, board has not. Now, there is not a single ground about TET. But the pleading state.
Yes.
Prayer for page 48, prayer 4 is their prayer at into September 2022. Now, your lordship was to consider whether this prayer was maintainable in September 2022. Forgetting the delay. This was their virtually main prayer.
Yes.
So my first point is this writ petitions was not maintainable, forgetting everything. Because the 10th August 2017 was cut-off date. According to the petitioner, 31st March 2016 was the cut-off date. No appointment could have given, so they could not have maintained any writ in 2022, seeking appointment as untrained candidates.
Thank you, Mr. Honorable.
And this is not maintainable. Now, delay, my lord, I had shown that my learned senior friend, Mr. Dotto, Kishore Dotto, had also given judgments. My lord, in my compilations, I have annexed 2 judgments, my lord. I'm not, I'll just refer it. And the delay, your lordship is aware that even the Supreme Court had held in several cases that even if you allege violation of fundamental right, I have read the entire writ petition. There was no allegations of violation of any fundamental right. At least they did not allege that Article 16 has been violated. Not a single pleading.
Yes.
So even for violation of fundamental rights, the Supreme Court has held that it could be general period of limitation prescribed on the Limitations Act for suit, 3 years. But there are other judgments of the Honorable Supreme Court which relaxed, that is for public interest litigations
As well as
and for pension holder and land acquisition cases, for long delay in getting compensation. Only those cases, but not in any other cases. This writ petition is for mandamus. Alleging, probably they did not allege, but I assume that there was an allegations of infringement of their legal right. There is no such allegations that what has been violated, what right they have got under what provisions of law, and that has been infringed. That is no such allegations.
Yes, which judgments you are relying upon, Mr. Bandhu?
The other issue, only one fact, I'd like to drop, since because they are seeking, one has achieved something, in SSC, so they will be seeking the same thing, the corruptions. Now the facts and figures I just mentioned for your noting, I have the documents, but I do not wish to, Act second, there was investigation ordered in a PIL. CBI and ED both conducted investigations. All the untrained candidates were given an appointment. Trained candidates, they were called. 2076 candidates, their appointments were doubted. And final list
Pertaining to which selection process?
in 2016 selection process.
2076
candidates. That was the primary first list which was prepared.
2076.
Only 2076. All are trained.
Yes. Then what happened?
And that was shortlisted. One by Justice Abhijit Ganguly, coming for terminating service of 269 trained candidates through board. The board was directed to terminate the service. Board terminated 269 candidates. The another was of 94 candidates. That is also for trained.
Terminated out of 2076. This is a 2016 process.
2016 process.
So the trained candidates, out of them, board was directed to cancel
269. আমি সব বলছি please.
269.
269, that is.
That was not challenged by the.
Yes,
person
this is now stayed by the Honorable Supreme Court.
in a separate litigation.
Separate, absolutely separate litigations, not here. This is trained, related
Pertaining
to
to the trained,
trained,
but 2016.
2016. Well, that whatever I gathered. Then out of these, another order, that was service of Justice Amrita Sinha, 94 candidates are directed to be terminated.
Out
Again,
of that 2076.
2069. 269, sorry, 269.
2076, you said.
2076 is the least prepared.
Total,
Out of
total.
that, 269 it was
terminated.
Then 94 terminated, directed to be terminated.
So this
by
is also pending before Supreme
Court. Those persons are still working, but all these, my lord, for trained. Not a single untrained candidate was listed by either by the CBI or by ED. Because why I am telling so, the entire allegations of the ED against Manik Sarkar, Manik Bhattacharya, was regarding this admission in the DLA training. They mainly, predominantly, those are the allegations. That he had taken some commissions from the training colleges. Those are the predominantly allegations both before the CBI and before the ED. And ED shortlisted only 5 candidates. I'm giving these numbers from CBI and ED both investigation, but ED allegation said only 5 candidates that too trained, their appointment was under scanner.
Yes.
But there is no allegations so far as the untrained candidates are concerned. And all untrained candidates, they were called by the CBI, their documents were verified by the CBI, and none of them has been listed in this 2076 number of candidates.
2076 is for detrained.
That is why, because but CBI has conducted investigation already.
Ultimately, the number of trained candidates appointment was more than 10,000.
12,000 around.
42,000 was the
11,000 and odd.
আচ্ছা, যাই হোক,
Out of that, matlab
076 came from which?
11,000 and odd.
So it is the same selection
Same
process.
selection process. What I am telling,
Not
when
trained,
the-
untrained. The procedure in the manner in which the selection process was conducted. Naturally, you are coming within that.
no. What I am saying,
076, you are harping on trained, untrained. We are not saying that. Both trained and untrained were pertaining to the.
no, I am saying for the CBI had carried out the verification process
Yes, that we
for
understand.
for untrained,
Trained.
for untrained and also trained. That is why I am saying that for trained and untrained both. And CBI found that not a single candidate who was untrained, their appointment is any doubt can be expressed.
What CBI law filed the charge sheet?
No, CBI filed a report before this court.
Charge sheet already filed.
Charge sheet.
That is the Somen Nunji Ramesh Malik matter, third supplementary charge sheet already filed by the CBI. In this selection, two investigation is going on, madam. I will apprise this court, madam.
10 candidates, and I am told
Original OMR sheet, one.
My lord, as per today, my lord, there is no allegation against the board. So all the charge sheet filed. No allegation.
and those who are not up in a 2018 process.
All right.
Now, another those are now pending before the Honorable Supreme Court. Nothing to do with these smaller untrained candidates. Nothing to do. They're
Selection-
separate proceedings.
The process was the same in which 2076.
No, different
2000
process.
How divided? 2016 recruitment process. Mr. Bandyopadhyay, 2016 is the one selection
is the
process.
initiation of selection
Let us
process.
understand. We are hearing argument on pertaining to 2016 selection process. And
No, Your
vis-a-vis-
Lordship is also hearing the argument of 2014 TET because those are the basis of the petition.
Take 2014 as well as selection process of 2016. Now in 2016 selection process, which was also marked through academic mark, date, interview and aptitude, both the trained and untrained were evaluated on the basis of that.
No,
right.
separate panels. Separate.
Panel may be separate. The procedure was the same. It is inex. We will listen to him. We are asking you today.
Those who are not TET qualified, those are found.
Mr.
Let
your
me-
chance. We have not asked for clarification from you. Please wait. Yes, Mr. Let us,
Yes,
Mr.
and let me finish, my lord.
Hmm.
But very easy for you to jump up, my lord, to rob livelihood of everybody when the writ petitions has no life.
Yes.
My lord, I have prepared a compilation.
Hmm.
So far as the delay, my lord,
Yes, we have got it.
so far as I will not read, my lord, I'm just pointing out the judgments.
Yes.
My lord, 1969, volume 1, SCC, page 110,
Hmm.
paragraphs, my lord, para 18, 39 and 40 is for the Honorable Justice Sikri,
18.
18, 39 and 40.
Yes.
And the Honorable Justice Bachwat, my lord, passed a separate judgment, my lord, for him, my lord, paragraph 65 and 66, on the same line.
This is on delay.
Delay when there is when there is an allegations of violation of fundamental rights, the court cannot stretch.
Yes.
Then, my lord, 2024, volume 3, SCC, page 148, paragraph. You will also kindly note the paragraphs only.
Yes.
Paragraph 15,
Hmm.
19.1 and 19.6. The next judgment, my lord, roving inquiry. This is the Supreme Court, my lord, made it specific, my lord, paragraph 25, that is 2009 5 SCC, page 641. As my learned friend Obrotos has submitted that in a writ proceedings of judicial procedure, no question of roving inquiry. The court cannot.
Paras.
Paragraph 25, my lord. Citation.
Yes.
শেষ করে দি আর ফালতু।
Yes. Any other judgment?
My lord, so far as the Sadanand, hello, kindly note
That
some
has been
paragraph because
placed.
all paragraphs have not been read. I'm just making the paragraph.
That is
Because-
2008.
Yes, 84 SCC,
Yes.
paragraph 58, 59, and 63. Now, why I'm saying so, you also will not find a contemporaneous letter, objections, or document challenging the selection procedure.
First letter was 2020.
2020. No letter. The first writ petition is 2022.
Hmm.
There's not a single demand justice.
Thank you, Mr. Bandhu.
Now, another judgment, I'll be just showing it. That is last judgment. I'm only giving reference. But for your lordship, my lord, I'm not reading. The last judgment, that is
No, don't say that the judge didn't hear you.
Pagol.
I have personally,
মারা পড়ে যাবো।
both of us, we had determined that we shall.
এত বড় সাহস হয়নি। I don't have the courage. But
2006.
2006-11 SCC, I don't know whether this is not in my compilation, but it has been attached in your lordship's judgment. Well, this is
No, today's P56. No.
SCC, page 356.
Yeah,
Now, this relates to the recruitment process of judicial service and executive officers of Punjab, Haryana, where the chairman of selection, the Public Service Commission was arrested. In a allegations was there was the bribery for the job. This was the allegations of the basis. Now the state government, there was inquiry initiated because since judicial officers appointment was also involved, the High Court constituted a committee and made an inquiry. On the basis of recommendations of the High Court, services of all were terminated by the state government. That is under challenge before the Honorable Supreme Court. The Supreme Court said, I mean, gist, I'll giving the paragraphs. It says that you cannot do so because each of candidates, there was no evidence that for each of
Took the money.
yes, all the candidates, their selections was bad. Because otherwise, the selection process was followed as per the rules. There was no allegations that the persons of the interview board, there was no allegations against them.
There
There
is
was
no
no
such allegation here also.
here also. That is why now ultimately since there was an inquiry report, Supreme Court segregated some and remanded back before the High Court to verify again that you cannot by sweeping. Now, why I am saying so? Since just now your lawsuit says the trained candidate, but the frame selection process. Now that verification has been done. They have been segregated. 269 and 94 have been directed to be terminated, which have been stayed in a separate proceeding. But there is nothing found so far as the trained candidates. The Honorable Supreme untrained candidates. So that cannot be paragraph facts. So far as the facts are concerned, paragraphs 2, 3, then paragraph 8, para 19, 20, paragraph 25A, paragraph 41, 66, 71, 19, 94, and last is 145.
71.
90, 94, and 145. First three judgments, I need not, you can see it. My lord, why I have relied upon? My lord, it is consistent, my lord, that in a futile rate, my lord, no order is generally passed by the High Court. This writ was futile, my lord, as on 2022. It was infructuous. It was not a public interest litigation. Not this division bench is hearing a public interest litigation or assumes a jurisdiction of a court of public interest, hearing public interest litigation. The mandamus appeal. That's all, my lord. I'm extremely grateful, my lord.
এটাকে এটা একসাথে লিখো।
Oh, that and